Hello, everyone, and welcome to Internet Law Review. For today's story, we have an opinion of the United States Supreme Court in the case of Escondido versus Emmons. And the very first thing that we should note is that this is a per curiam opinion. Per curiam means that it is issued by the court in the name of the court itself. So there is no listed author of the opinion like there is in most cases. Per curiam decisions are typically issued in relatively uncontroversial matters, where the law is upholding what is already there in place, and so the court is basically signaling that this is just par for the course, and there's really not much to see here. But that is not always true. In fact, one of the most controversial decisions of all time, the decision of Bush v. Gore, was also a per curiam decision, even though it was a highly fractionated vote. So when the rules are for per curiam basically is any time the court feels like it. There's no real official rule, but it is meant to signal that the court is speaking as a united whole rather than it being authored by a particular person, and is typically uncontroversial, of course, with the notable exceptions such as Bush v. Gore being the thing that tests the rule. In any case, let's see what the United States Supreme Court had to say in this particular case, Escondido versus Emmons, which deals with qualified immunity as it relates to police. The question in this qualified immunity case is whether two police officers violated clearly established law when they forcibly apprehended a man at a scene of a reported domestic violence incident. The record, viewed in the light most favorable to the plaintiff, shows the following. In April 2013, Escondido police received a 911 call from Maggie Emmons about a domestic violence incident at her apartment. Emmons lived at the apartment with her husband, her two children, and a roommate, Amitra Douglas. Officer Jake Huskin responded to the scene and eventually helped take a domestic violence report from Emmons about the injuries caused by her husband. The officers arrested her husband, and he was later released. A few weeks later, on May 27, 2013, at about 2:30 p.m., Escondido police received a 911 call about another possible domestic disturbance at the Emmons apartment. That 911 call came from Amitra Douglas's mother, Trina Douglas. Trina Douglas was not at the apartment, but she was on the phone with her daughter Amitra, who was at the apartment. Trina heard her daughter Amitra and Maggie Emmons yelling at each other and heard her daughter screaming for help. The call then discontinued, and Trina Douglas called 911. Officer Husson again responded, along with Robert Craig. The dispatcher informed the officers that two children could be in the residence, and calls to the apartment had gone unanswered. Police body camera video of the officers' actions at the apartment is in the record. The officers knocked on the door of the apartment. No one answered, but a side window was open, and the officers spoke with Emmons through that window, attempting to convince her to open the door to the apartment so they could conduct a welfare check. A man in the apartment also told Emmons to back away from the window, but officers said that they could not identify the man. At some point during this exchange, Sergeant Kevin Toth, Officer Joseph Levingwell, and Officer Hugh Quach arrived as backup. A few minutes later, a man opened the apartment door and came outside. At that point, Officer Craig was standing alone just outside the door. Officer Craig told the man not to close the door, but the man closed the door and tried to brush past Officer Craig. Officer Craig stopped the man, took him quickly to the ground, and handcuffed him. Officer Craig did not hit the man or display any weapon. The video shows that the man was not in any visible or audible pain as a result of the takedown or while on the ground. Within a few minutes, officers helped the man up and arrested him for a misdemeanor offense of resisting and delaying a police officer. The man turned out to be Maggie Emmons' father, Marty Emmons. Marty Emmons later sued Officer Craig and Sergeant Toth, among others, under California Statute, Revised Statute 1979, and United States Law 42 U.S.C. 1983, which is the law that you use principally when you're suing an officer of a state government, is 42 U.S.C. 1983. He raised several claims, including, as relevant here, a claim of excessive force in violation of the Fourth Amendment. The suit sought money damages for which Officer Craig and Sergeant Toth would be personally liable, so we're seeking them in their personal capacity rather than official capacity. The district court held that the officers had probable cause to arrest Marty Emmons for the misdemeanor offense. The Ninth Circuit did not disturb that finding, and there is no claim presently before us that the officers lacked probable cause to arrest Marty Emmons. The only claim before us is that the officers used excessive force in effectuating the arrest. The district court rejected the claim of excessive force. The district court stated that the video showed that the officers acted professionally and respectfully in their encounter at the apartment. Because only Officer Craig used any force at all, the district court granted summary judgment to Sergeant Toth on the excessive force claim, making sense because if it is a violation of law, only the person who's directly involved should probably be liable, so that makes sense. Applying this court's precedence on qualified immunity, the district court also granted summary judgment to Officer Craig. According to the district court, the law did not clearly establish that Officer Craig could not take down an arrestee in that circumstance. The clearly established thing is the dominant aspect of the law in this area, which I will cover in more depth a little bit later. The court explained that the officers were responding to a domestic dispute and that the encounter had escalated when the officers could not enter the apartment to conduct a welfare check. The district court also noted that when Marty Emmons exited the apartment, none of the officers knew whether he was armed or dangerous or whether he had injured any individuals inside the apartment. The Court of Appeals reversed and remanded for trial on the excessive force claims against both Officer Craig and Sergeant Toth. The Ninth Circuit's entire relevancy analysis of the qualified immunity consisted of the following. The right to be free of excessive force was clearly established at the time of the events in question. So the Ninth Circuit said that there was a clearly established standard and that the trial court failed to consider it, so asked the trial court to take another look at it in light of that. The Supreme Court, speaking for itself, says, "We reverse the judgment of the Court of Appeals as to Sergeant Toth and vacate and remand as to Officer Craig." With respect to Sergeant Toth, the Ninth Circuit offered no explanation for its decision. The court's unexplained restatement of the excessive force claim against Sergeant Toth was erroneous and quite puzzling in light of the district court's conclusion that only Defendant Craig was involved in the excessive force claim and that Emmons failed to identify contrary evidence. I would tend to agree with the United States Supreme Court case here. If the district court says that only Defendant Craig was involved, the Ninth Circuit has no basis to ask the district court to take another look with respect to anyone other than Defendant Craig, because the trial court is the trier of facts. So the trial court has factually established that only Defendant Craig was involved. Therefore, the Ninth Circuit, unless they can show the district court was clearly in error, which they did not show, has no power to overturn a factual finding of the lower court below. So the Supreme Court is completely correct here. A merely conclusory statement is nowhere near enough for the Court of Appeals to overturn a factual statement or a legal statement which relies on that factual statement of the lower court. So the court was completely correct to reverse with respect to anyone other than Defendant Craig. Well, what about Defendant Craig, you might ask? The trial court did establish that he was factually involved, and so the only standard is the legal standard. So was the Ninth Circuit correct there? Well, as to Officer Craig, the Ninth Circuit also erred. As we, the Supreme Court, have explained many times, qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. The Supreme Court emphasizes that the qualified immunity standard is particularly important in excessive force cases, as they've explained. Specifically, it is especially important in the Fourth Amendment context, where the court has recognized that it is sometimes difficult for an officer to determine how relevant legal doctrine, here excessive force, will apply to factual situations the officer confronts. Use of excessive force is an area of law in which the result depends very much on the facts of each case, and thus police officers are entitled to qualified immunity unless existing precedent squarely governs the specific facts at issue. It does not suffice for the court simply to state that an officer may not use unreasonable and excessive force, deny qualified immunity, and then remit the case for trial on the question of reasonableness. An officer cannot be said to have violated a clearly established right unless that right's contours were sufficiently definite that any reasonable officer in the defendant's shoes would have understood that he was violating it. In this case, the Court of Appeals contravened those settled principles. The Court of Appeals should have asked whether clearly established law prohibited the officers from stopping and taking down a man in these circumstances. Instead, the Court of Appeals defined the clearly established right at a high level of generality by saying only that the right to be free of excessive force was clearly established. With that right defined at a high level of generality, the Court of Appeals then denied qualified immunity to the officers and remanded the case for trial. Under our precedents, the Court of Appeals' formulation of the clearly established right was far too general. To be sure, the Court of Appeals cited the Gravelet-Blondin case from that circuit, which described a right to be free from the application of non-trivial force for engaging in a mere passive resistance. Assuming, without deciding, that a Court of Appeals decision may constitute clearly established law for the purposes of qualified immunity, the Ninth Circuit's decision involved a police force against an individual engaged in passive resistance. The Court of Appeals made no effort to explain how that case law prohibited Officer Craig's actions in this case, and that is a problem under our precedents. The Supreme Court citing itself. We have stressed that the need to identify a case where an officer acted under similar circumstances was held to violate the Fourth Amendment. While there does not have to be a case directly on point, existing precedent must place the lawlessness of the particular action beyond debate. Of course, there can be the rare obvious case in which the unlawfulness of an officer's conduct is sufficiently clear, even though existing precedent does not address a similar circumstance. But a body of relevant case law is usually necessary to clearly establish that answer. The Court of Appeals failed to properly analyze whether clearly established law barred Officer Craig from stopping and taking down Marty Emmons in the manner as Emmons entered the apartment. Therefore, we remand the case to the Court of Appeals to conduct the analysis required by our precedent with respect to whether Officer Craig is entitled to qualified immunity. The petition for cert is granted, the judgment of the Court of Appeals is reversed in part and vacated in part, and the case is remanded for further proceedings consistent with this opinion. So, let's discuss the law as it relates to qualified immunity. Qualified immunity is a doctrine that basically says that any government official, when they're acting in their capacity as a government official, is entitled to some protection so they don't have to worry about the actions that they perform in service of their job coming back to bite them in a personal capacity. And the rationale is obvious. When you work for the government, you're asked and required to do many things. And if you could be held personally liable, the idea of taking a government job would be much less attractive. However, we don't want government officials to have an absolute immunity, so that anything they do is automatically covered. That would go too far. So the United States Supreme Court has developed this area of qualified immunity. The idea being that as long as you're doing things within the scope of your job, and there is no law or decision or case law that clearly says what you're doing is wrong, that you have discretion to apply the law to the best of your understanding. And this goes extra true for police officials, as the Supreme Court notes. And again, the rationale is obvious. While a bureaucratic official sitting in a nice office somewhere would have time to consider their decisions, a police officer in the throes of an imminent threat or imminent situation doesn't have that same comfort. And so the case law gives police officers an extra dose of this qualified immunity because of the realities of their job. We want police to be guardians of us, and we also want to make sure that when they're executing their decisions, they don't have to worry that the decisions they're going to make may come back to haunt them in a personal way, unless those actions are in violation of clear law. There was one note here that the Supreme Court gave that I thought was interesting. The Supreme Court did say explicitly that there could be some situations in which something is so vile or so reprehensible that you do not need case law to the contrary. That is an important marker for this, and I think indicates the United States Supreme Court at least letting open the door of them trying to rein in qualified immunity. Qualified immunity has become deeply controversial in recent years, particularly due to police actions that were excessive. And so the courts have looked somewhat to rein in the scope of qualified immunity. The Supreme Court, in their past decisions, has all but indicated a desire to rein in qualified immunity. So this line from the Supreme Court relating to things that are in gross excess, even where there is not case law, does seem to be a step along that road. However, reining in qualified immunity looks like it's going to have to wait for another day, and the Supreme Court doesn't certainly seem ready here to do away with the doctrine of qualified immunity altogether. So we are going to have to pay attention to this area of law, because it is an area of law in both which courts and lawyers and the public have begun to desire some constraint on qualified immunity doctrine with respect to the police, so that we don't have to worry so much about gross excesses of police force. And we'll have to see how that develops in future cases. But at least for today, it looks like these particular officers did not violate qualified immunity, at least on the tenor of the Supreme Court's opinion, and I would tend to agree. And this also shows the benefit of body cameras. Because there were body cameras that showed exactly what the police can do, it makes the facts much easier to establish. So I think this is good validation, as any, that we should have body cameras so these become less subjective and more objective on the facts, so that the courts are better able in a position to decide the law as it should be as it relates to these incidents. For now, my friends, that is all. I hope you're well. Until later, my friends, cheers and goodbye.